Yeah, that is better. But separate as much as possible. Members of the same family can sit together. Or all of y'all in the same family?
My daughter and my wife back there, I got to put her in the back. No, not really.
All right. We're going to do.
Before we start that, Judge, would it be okay for me to visit with Mr. Richardson outside of the courtroom?
All right, I believe we're ready to begin. I call cause number 10,277 for the case style, the state of Texas versus Keith Matthew Owen. For the record, this is a pretrial hearing. It is being conducted by remote video teleconferencing technology using the Zoom protocol. This proceeding is also being live streamed on the court's YouTube channel in order to comply with Supreme Court directives and Office of Court Administration directives that the public be provided access. I will advise all parties that I have issued an order prohibiting the recording of this proceeding in any manner, whether electronically or otherwise, because the official court reporter is present in this Zoom hearing, recording all of this proceeding, just as he would do if we were in the courtroom doing this in person or in present with everyone present. That said, for purposes of pretrial in Mr. Owen's case, what says the state?
State's ready, Your Honor.
And the defense, Ms. Fuller?
We're ready, Your Honor.
And we also note that Mr. Owen is present in this Zoom video teleconferencing proceeding. Do we have any pretrial matters to take up in Mr. Owen's case today?
The state does not, Your Honor, other than to just request a setting.
You know, the defense doesn't have any pretrial matters for the court to consider, and obviously we consent to a setting as well.
Do the parties have a particular date that they would suggest for the setting?
I don't, Your Honor. I'm not in a hurry to get it set, but I would suggest or request not earlier than the week of the 28th. In other words, not next week.
Yes. Ms. Fuller, let me give you some input as well. I will have matters set on the 28th.
Judge, I would request a setting in January if possible.
All right. I frankly think that's not just a reasonable request, but considering the timing of the holidays, that's probably something we ought to do. What about the morning of the 11th or 12th? Or I could do it the morning of the 6th of January also. I was just thinking that might be a time when we have other people trying to take care of their cases.
Any of those times are fine with me. If I had my preference, it'd be the 11th or the 12th, Judge. For that reason you mentioned. That's
Right.
week usually.
Judge, I have show a final hearing on the 12th in your court on Pena. Do you have that? 9 o'clock?
For some reason, I do not have it written down, but let me double check.
Judge, may I?
Yes, please.
Pena is February 9th.
When do I have that on the 12th? Oh, I have it on the 9th too. Maybe I was going to have it for 2 days. The 12th is good, Your Honor, in the morning.
Does that otherwise work on our schedule, Ms. Coordinator?
Yes, sir.
All right, then let's set it at 9 a.m. on the 9th. How long do we think it will take to try? If it's
Your Honor,
contested.
the 12th.
Your Honor.
9 o'clock on the 12th. Yes, ma'am.
Judge, the state's evidence won't take more than 30 minutes, I would think.
Your Honor, I would think an hour would be sufficient.
Let's set it at 9:30. Give you each of you just a little bit more time to get that ready that morning. Is that acceptable to each of you?
Yes, sir.
Or to you? You're muted. Sorry.
Yes, sir. January 12th at 9:30, Your Honor.
Okay. And then we'll send notice out to that effect. Is there anything else then that we need to take up in Mr. Owen's case at this time?
Not from the state, Your Honor.
No, sir. Thank you, sir.
You're welcome. Thank you, Mr. Owen. You may be excused.
Well, don't find me coming. What number was that?
10-277.
It's easier to ask you than to look.
Oh, sure. it would be. Are you Mr. Dela Cruz?
Yes, sir.
Judge, that's the only other plea I have is Jane Gutierrez, and I'm sorry. Pretrial is Miss Gutierrez, and she's not in jail.
Other than Mr. Dela Cruz? Is that what
Yes.
you're saying?
Yes, sir. But
All right.
I'm fine with doing him if you want to do him now since he's there. But he's a plea.
Oh, he is a plea?
Yes, sir.
Oh, I had the papers and I was looking for them, and the court reporter was taking information off of them, and so he had the papers instead of me. Where Mrs. Fuller is Miss Gonzalez?
She is supposed to be dialing in, Your Honor. Or she may be there. I'm not. She may be out in the hall if she can't dial in. She was told to either dial in or show up in person.
We'll check. We're checking.
Judge,
Yes.
she called probably 10 minutes ago and said she was going to get on the Zoom.
Did she say when she was going to get on the Zoom?
I told her to get on. It was just before Jeannie got on. So I told her to get on then.
All right. She hasn't done that. All right. We need to have the notary, which will be Mr. Hanshu, notarize signatures of Mr. De La Cruz on certain instruments. And so I'm going to mute myself and my computer so that he can have that conversation with Mr. De La Cruz. I don't know. It will be in the presence of the DA as well. So we're going to pause to allow Mr. Hanshu to take care of that.
Mr. Del Cruz, I'm going to hold up this. It's that application for probation. Did you go over this with your attorney, and is that your signature?
Yes, sir. Yes, sir.
And then the same thing, this stipulation of evidence, can you see that?
Yes, sir. Yes, sir.
Did you go over this paper with your attorney?
Yes,
Do
sir.
you swear everything in there is true, and is that your signature?
Yes, sir.
Thank you.
All right, I'm ready to proceed with Mr. De La Cruz plea. So let me call cause number 10,831. The case is styled the state of Texas versus Artemio Sanon De La Cruz. This is a hearing wherein the court has been informed that the defendant desires to enter a plea of guilty to the charges in the indictment and to do so pursuant to a plea agreement between defense and state. This plea hearing is being conducted by remote video teleconferencing technology using the Zoom protocol. The proceeding is also being live streamed on the court's YouTube channel. In order to comply with Supreme Court and Office of Court Administration directives allowing for public access to the courts when the courts are using Zoom technology or remote video technology for the hearings. Because these are being live streamed and are being conducted, or because this hearing is being conducted by remote video technology and teleconferencing technology and being live streamed by the courts on the court's YouTube channel, the court hereby orders that no part of this proceeding is to be recorded by any person using any means whatsoever, whether electronic or otherwise. And that's because these proceedings are being recorded by the court's official court reporter, just as if we were in court in person. With those comments, I next recognize State's counsel for purposes of this plea hearing. Is the state ready to proceed?
State's ready, Your Honor.
And now I ask, is defense ready to proceed?
We are ready to proceed, Your Honor.
Are you Artemio Sinon de la Cruz?
Yes, sir.
Mr. de la Cruz, an indictment has been returned into this court charging you with a state jail felony offense of possession of a controlled substance. Under the law, you have the right to have someone read the indictment out loud to you. Do you wish to have someone read the indictment out loud to you?
Well, I mean, it don't mind. Well, I know what I'm getting charged for.
If you know, do you wish to have the indictment read to you?
Sure, why not? Yes, sir. Yes, sir.
Mr. Smith, read the indictment.
Yes, Your Honor. In the name and by authority of the state of Texas, the grand jurors for the county of Scurry, state of Texas, duly selected, impaneled, sworn, charged, and organized as such at the July-December term AD 2020 of the 132nd Judicial District Court for said county, upon their oaths, present in and to the court that Artemio Sinon de la Cruz, on or about the 4th day of August 2020, and before the presentment of this indictment in said county and state, did then and there intentionally or knowingly possess a controlled substance, namely methamphetamine, in an amount of less than 1 gram, against the peace and dignity of the state, signed by the foreman of the grand jury.
Mr. de la Cruz, do you understand that that indictment that was just read to you charges you with a state jail felony offense of possession of a controlled substance, namely methamphetamine?
Yes, sir.
Understanding the charge, to that charge, how do you plead? Guilty or not guilty?
Guilty.
Do you understand that you do not have to enter a plea of guilty? You have the absolute right to enter a plea of not guilty. And further, you have the right to not have it used or held against you in any way just because you might exercise your right. Do you understand that?
Yes, sir.
You also have the right to have a minimum of 10 days notice of the charges in the indictment. A little over a month ago, you and your attorney filed a document entitled Waiver of Arraignment, which among other things said that you had seen or received a copy of the indictment. You waived the reading of it at that time, and you stated you knew what you were charged with. So you've had more than 10 days notice of the charges. Nevertheless, I will grant to you some additional time if you wish to have it. You also have the right to have a jury hear your case and thus have a jury trial. And that's true even if you enter a plea of guilty, as you just said you wish to do. do you understand that you have the right to a jury trial?
Yes, sir.
Now, I have been handed a document entitled Waiver of Defendant, which has been, I've already said, which has been presented to me. Did you know that when you signed that document, you were giving up the opportunity to have more time to prepare, and you were giving up the right to have a jury trial? Did you know that?
Yes, sir.
Is that what you still wish to do?
Yes, sir.
Mrs. Fuller, your signature is also on this document. Is that to evidence that you are joining your client in these waivers?
Yes, sir.
Mr. Smith, your signature is also on this document. Is that evidencing the state's joinder in the waiver of the right to jury trial?
Yes, Your Honor.
All right, I will accept those waivers and so note by signing. Mr. De La Cruz, there are other rights and admonitions I need to discuss with you. Let me begin by talking about the range of penalties that exist for a state jail felony, such as is charged against you in this indictment. A state jail felony carries a range of penalties running from 180 days up to 2 years in state jail. It also carries the possibility that a fine could be imposed, and if imposed, it would be in some amount not to exceed $10,000. You understand that's the possible range of penalties you face if you were to be convicted of this charge.
Yes, sir.
Then let me go on and discuss other matters with you. First, I tell you that I am aware that a plea agreement exists in your case. I have been handed a copy of the plea agreement, or actually, I guess the original of the plea agreement. And I tell you now that I do not have to follow the plea agreement.
Yes, sir.
I do have to tell you if I'm going to follow it or not. Because if I decide not to follow the plea agreement, then the law would give you another right, which would be the right to take back your guilty plea. If I don't follow your plea agreement, you don't have to continue to enter the plea of guilty. You could take it back. And if that happens, we just start all over. And none of these papers that you've signed and nothing you have said for this hearing, like pleading guilty, none of that would be used against you when we go forward at a later time with your trial. That's what happens if I don't follow your plea agreement. But let me tell you what happens if I do follow your plea agreement. If I do follow it, then the law says you will be bound by the terms of that plea agreement. You will not be able to get out of the terms of the plea agreement if I follow it. In any way, you won't be able to appeal your case if I follow your plea agreement. Now, that's contrary to the normal rule. The normal rule is you have the right to appeal, even from a plea bargain agreement, unless a part of your plea agreement says you give up the right to appeal as a part of the agreement. Your plea agreement has that provision marked. And so it means if I follow your plea agreement, you cannot appeal at all. Do you understand that?
Yes, sir.
Then let's go further. And I will ask you some questions I'm required by statutes and Texas court decisions. And my first such question is, are you a citizen of the United States of America?
Yes, sir.
Where were you born?
In Snyder, Texas.
My next question asks, do you consider yourself to be mentally competent?
Yes, sir.
Do you know what's going on in these proceedings?
Yes, sir.
Have you been able to understand the charges against you so that you could discuss those charges with your attorney and get her advice about what the law is and how the law might affect or be affected by the facts of your case? In other words, have you cooperated with her in her efforts to represent you defending these matters?
Yes, sir.
Mrs. Fuller, do you believe your client is mentally competent?
I do, Your Honor.
I accept that representation. And Mr. De La Cruz, it appears to the court as well that you're mentally competent, and I make that finding. Mr. De La Cruz, my next question asks, are you satisfied with the legal representation your attorney has provided to you in these matters?
Yes, sir.
And let me tell you why I asked that question, because I'm not trying to suggest that you wouldn't be or shouldn't be satisfied. Instead, I'd ask the question just to give you a chance to tell me if you were not satisfied. If you thought her work was somehow deficient or legally ineffective, my question would give you the chance to tell me, and we would work to try to correct any problems that existed if there were any. Do you understand that?
Yes, sir.
Now, let me also tell you that since I've given you the chance to let me know if there's any problems with the attorney's representation, that necessarily means you're not likely to be successful if you wait till some later date to say your lawyer didn't do a good job. In other words, now is the time to do that so we can still get it corrected if there were a problem. Do you understand that?
Yes, sir.
And understanding that, are you still telling me you're satisfied with the legal representation you've received in these matters?
Yes, sir. I'm satisfied with it.
All right. Then let's go further in this plea discussion. And let me ask you another question or two about your decision to enter this plea of guilty. The law says I must be satisfied that this is your decision to plead guilty, that you do so freely and voluntarily. And so I ask these questions. Has anybody threatened you or forced you or tricked you or in any way tried to make you enter a plea of guilty to these charges when you would not otherwise do so?
No, sir.
Has anyone promised that you would get something of value just to get you to plead guilty when you would not otherwise do so?
No, sir.
Are you telling me then that you're pleading guilty to this charge because the truth is you are guilty of this charge, and that's the only reason you would plead guilty to such a charge?
Yes, sir. And plus, I'm owning up to my mistakes.
All right, sir. I believe that's all the questions I have at this moment. Mr. Smith, you may proceed.
Your Honor, the state offers for evidence a document which is marked as State's Exhibit 1, that document being this defendant's signed and sworn stipulation of evidence in this case.
We have no objection, Your Honor, to your receipt of the stipulation.
Mr. De La Cruz, let me talk to you about the stipulation, because there are other rights that are talked about in the stipulation, and I want to make sure that you and I understand what those are. Let me tell you that the state is required to produce some evidence tending to show your guilt, even though you are pleading guilty. And that's a part of our law because it helps to make sure that another right that belongs to you is in fact given to you or observed in your favor. That other right that I'm talking about is your right. The legal expression is to confront the witnesses against you. So what does that mean? It means you have the right to require the state to bring their witnesses into court, to have them be sworn in and under oath testify about the things that they would say show that you committed this offense. As I say, we call that the right to confront the witnesses. But the stipulation of evidence says you're giving up that right to confront witnesses, and instead you're telling the state they don't have to bring their witnesses into court at all. Did you realize that was a part of the stipulation when you signed it?
Yes, sir.
The stipulation also says that you are aware that you have the right to remain silent, as well as the right to be free from self-incrimination, which is the right to not be forced to give evidence against yourself. And instead, you are giving evidence against yourself because the stipulation says that this is a confession, a judicial confession, wherein you are admitting all of the material allegations set out in the indictment, namely that you possess the methamphetamine, just like it is charged against you in the indictment. Did you realize you were admitting or confessing to committing the offense when you signed the stipulation?
Yes, sir.
And do you understand that that provides the state with some evidence satisfying their obligation to present some evidence tending to show your guilt?
Yes, sir.
One last question about the stipulation. There is another sentence paragraph in the stipulation that says that you are aware that there are court costs in the sum of $290, that there is a restitution obligation of $180, and there's reimbursements to this county in the sum of $665 for reimbursement fees. Did you see that and know that that was in the stipulation of evidence also?
Yes, sir.
Then State's Exhibit 1, the signed sworn stipulation of evidence, is received as evidence in this cause.
State rest, Your Honor.
Defense also rests, Your Honor.
State closes.
Defense would close as well. Your Honor, may I ask a question?
Yes, Ms. Fuller. Hold on a second. Hold on a second, please. Ms. Coordinator, have you heard from the probation officer?
No, sir.
Would you
Would
see?
you like me?
Yes, see if you can get them on right now.
Okay.
Okay, Mrs. Fuller, you started to ask a question.
Sorry, Judge. I wanted to double check before we get into the terms of probation, the address that I wrote in there with Mr. Dela Cruz. I meant to do that before we got started and I forgot because I wrote that address in and I just want to make sure that's the correct address in Hermely.
You want to ask him? You want me to ask him?
You can ask him, Your Honor, when we get to the terms and when you start going over the terms and conditions.
Okay.
I meant to ask before we got started and I forgot.
That's all right. That's something we routinely ask anyway, and so we'll get to that. Mr. De La Cruz, I have been presented with a plea bargain agreement. You and I have already mentioned that. Let me go over the plea bargain agreement with you so that I can make sure that you and I understand it the same way.
Yes, sir.
All right. As I'm understanding the plea agreement, as I'm looking at it again, it says that you will enter a plea of guilty as you have done. It says that's going to result in a 2-year state jail sentence with a fine of $1,500, court costs in the amount of $290, and reimbursement fees in the amount of $665. But the plea agreement also says that you will be granted probation for a period of 5 years, which to me means that the sentence of confinement will be suspended, and instead of going to state jail, you will be placed on probation and allowed to be on probation as long as you follow all the rules of probation. Now, the plea agreement also says that you will be ordered to pay restitution in the sum of $180. It says you will waive your right to appeal, as you and I have already discussed. And it says that while on probation, you will participate in what we call the TAP program, which stands for Treatment Alternatives to Incarceration Program. Really, that's an assessment, a treatment and counseling based upon the assessment for people who have drug or alcohol related problems. Now, all of that is my understanding of the plea bargain agreement. Is that the same as your understanding of the plea bargain agreement?
Yes, sir.
Are you asking me to approve the plea bargain agreement?
I mean, that's what I would like, but I mean, it's all up to you, sir. I mean, I'm gonna respect what you got going on. I mean, I can't go against what you got.
I understand, and I appreciate your expression of respect for the court. But my question is, I will take into consideration your request. And so my question is, are you asking me, requesting me to approve the plea bargain agreement?
Yes, sir.
Mrs. Fuller, have I stated the plea bargain agreement accurately as you understand it to exist?
You have, Your Honor.
Mr. Smith, have I stated the plea bargain agreement accurately as you understand it to exist?
Yes, Your Honor.
All right. I advise, as I said I would, one way or the other, I advise that I will accept and approve the plea bargain agreement. All right, and cause number 10,831 for the case style, the state of Texas versus Artemio Sanon de la Cruz. Mr. de la Cruz, based upon your plea of guilty, based upon the evidence you stipulated to, I find that you are guilty of the offense of possession of a controlled substance, a state jail felony. Having pronounced you guilty, do you know of any legal reason why a sentence should not be imposed at this time?
Sir.
Then, following your plea bargain agreement, as I said I would do, I hereby sentence you to serve 2 years confinement in state jail, order you to pay a fine of $1,500. I assess court cost in the amount of $290, and order you to pay reimbursement fees totaling $665. But I also follow the plea agreement and suspend the imposition of confinement and instead place you on probation for a period of 5 years, provided you can follow all of the rules of probation. And so let me ask you, do you understand what all of the rules of probation, what they are?
Yes, sir.
Can you follow these rules of probation?
Yes, sir.
Will you follow these rules of probation?
Yes, sir. I got no choice.
Well, you do have a choice. If you don't follow the rules, your choice would be to go to the penitentiary. Do you understand that?
Yes, sir.
Okay. And so is it your commitment to me? Because if you cannot or will not follow the rules, quite frankly, you're wasting your time. So,
I will follow the rules, sir.
okay. That's
I
what I
will
wanted to know.
follow the rules.
My next question is, may sound a little bit dumb, especially for someone as intelligent as you, but I need to put it on the record. Are you able to read and write the English language?
Yes, sir.
Then I will cause a copy of the rules of probation and the judgment to be given to you so you can read them anytime you want to, just familiarizing yourself with the rules and what you're supposed to do. That also saves me from reading all of the rules to you, since you can read them yourself. And so instead of reading the rules to you, I want to emphasize some of them to you. And these are the rules that I'm going to emphasize that I see causing the most trouble for people who are placed on probation. And by trouble, I mean people have violated these rules more than others. We don't want you to violate any rules. We want you to be successful and complete your probation satisfactorily. That's what we desire, and we'll do what we can to assist you. But you need to know that if you don't follow the rules, then your probation could be revoked and you could be sent to state jail. Do you understand that?
Yes, sir.
All right, so let me talk about the rules that I want to emphasize. First, don't break the law. Not here or anywhere else. You cannot expect to stay on probation if you're out there breaking the law. Next, stay away from drugs and alcohol. This is a drug case, your case. So you need to stay away from drugs. Most everybody needs to do that anyway. But you also need to stay away from alcohol. Don't go to places where alcohol is sold, served, consumed, or possessed. You can, but I will make some exceptions. You can go into a grocery store, you can go into a convenience store, and you can go into a restaurant, even though those are places where alcohol is sold. You just can't buy it, hold it, that is, possess it. You can't consume it. You can't share it with others. Do you understand that?
Yes, sir.
The orders for probation say that you reside at 973 Willis Avenue in Hermley, Texas. Is that your correct address?
Yes, sir.
You will continue to live at that address. You will not move someplace else unless you get permission from your probation officers,
Yes,
which,
sir.
by the way, will be easily obtained. They're not going to try to keep you from moving. They just want to know where you are going to be and to make sure you're not going to be in some place that's going to get you in trouble.
Yes, sir.
While on probation, you will report to your probation officers each month before the 5th day of each month. And you'll do that here in Snyder at the probation office across the street from the courthouse. While on probation, you will allow probation officers and law enforcement officers to search you and your property. And in fact, the rule says if they ask you for permission to search, if you say no, that violates your probation, even if you don't have anything on you that would be a violation of probation. So the easiest thing is don't have anything on you that would cause your probation to be violated or that would be a violation of the law. And if you're asked, you allow them to search.
Yes, sir.
While on probation, in addition to paying the fine and the court costs, the reimbursement fees I've already mentioned, you will also be ordered to pay restitution in the sum of $180. All of that totals $2,635. And I find in the paperwork presented to me a request that you be allowed to pay that at the rate of $45 per month. Is that your request?
Yes, sir.
Do you understand that there is also a probation service fee of $60 that will be due each and every month as well?
Yes, sir.
Those two together total $105. Can you afford to pay $105 each and every month and still take care of your needs and the needs of your dependents?
Yes, sir.
All right, I'll approve that request. While on probation, you'll observe a curfew. You will not leave this county for more than 3 days without permission. Now, if you're just going to be gone for 1 day or up to 3 days, you can do that without having to ask for permission. But if you're going to plan to be gone more than 3 days, you need to ask permission.
Yes, sir.
While on probation, you'll perform 160 hours of community service restitution. And the probation office will work with you and tell you places that are acceptable to do that. You must do at least 10 hours per month until you get that 160 hours finished. While on probation, you will come back to see me for a probation performance review. Let me see when that will be due, March 11 of 2021. You'll come back to see me on the 11th day of March 2021 for the first of several probation performance reviews. We will schedule them as often as is necessary. But if you are continuing to follow all the rules and not having any problems, we'll make them further and further apart until we all decide that it's not necessary to see you so often, and we'll stop those. On March 11, I have 2 times that I hear probation performance reviews. One is at 9:30 in the morning, one is at 1:30 in the afternoon. I will give you your preference when you will report on that date. So what's your preference, morning or afternoon?
Probably afternoon.
All right, sir. So 1:30 p.m. will be your report time on March 11, 2021. As I've said, these are not all of the rules of probation. And since I haven't mentioned all of the rules, let me give you a chance to ask any questions you have about any of the other rules that you've looked at, or if you have any questions about anything I have emphasized, I will give you that chance also. Do you have any questions?
Yes, sir. Okay, I got a question. Like, say if I have to transfer, am I allowed to transfer?
By transfer, you mean to another county?
Yes, sir.
That would be a move to another county. There are 2 things involved in that, at least 2. One, you have to get permission from your probation officers. And I've already told you that's not hard to obtain. They're not going to try to keep you from moving.
Yeah, I understand that.
Okay. But the county where you want to transfer to also must agree to allow you in their county. And so we have to get their permission. Now, usually that's not that difficult, but they will require you to already have a place to live, and they will want to know why you are moving there. For instance, if it's to have a job there, or because you have family members there, or whatever the reason is, they want to know that as well. And so, go ahead.
I got an aunt that lives in Abilene, and she's willing to help me. Pretty much, she can help me get a job, and she's willing to help me get a place and all that, and be stable. And I mean, my grandma's house is not really livable. That's the house that I got right now. That's where I'm gonna go to right now. And here in Harmony, the state is really trying to shut that house down, but we don't know when.
I understand. I don't think that will be any problem at all, but it is a process that we, with you, need to check into. Ordinarily, we have probationers transfer their probation all the time.
Yes, sir.
So yes, it is possible. It's based upon the small information you gave me. It certainly is possible, and with more information, it may be very easy to do.
Yes, sir.
That's something you'll discuss with your probation officer.
Okay.
All right. Do you have any other questions?
No, sir.
Then those will be the orders of the court. You will be processed out of jail, and you will report to the probation officer today. Ms. Duggan, what time or when?
1 o'clock, and to see Chris Oliver.
Do you understand that, to Mr. De La
Yes,
Cruz?
sir. Yes, ma'am.
And do you know where that is?
Right in front of the courthouse.
Yes, sir, right across the street from the courthouse.
Okay.
All right, Mrs. Fuller, do you have anything else?
I do not, Your Honor, and would just thank you for allowing us to do this plea at the time today.
Yes, ma'am. Anything further from the state?
No, Your Honor. Thank you.
All right, then we will be in recess in Mr. De La Cruz's case. I'm going to close our Zoom. She's here. I'm going to close our Zoom hearing from the jail, but the rest of us will remain on the Zoom conference because we have one more pretrial. Ms. Gonzalez has just entered the waiting room. Mr. De La Cruz, thank you, sir. You may be excused. They will take care of you and process you out of the jail this morning.
Okay. Y'all have a good day.
Thank you, sir.
Judge, would it be possible for me to have a breakout room with Miss Gonzalez just briefly?
Yes, ma'am.
Thank you.
Let me admit her first.
Judge, is all the paperwork at the courthouse, the judgment?
Yes, ma'am.
You have all of it? Okay, I'll send Chris to get it.
Okay.
Hey, Shelley,
Yes.
and I have the document that I usually give to you guys in the courtroom. The defendant signs saying they understand their rules of probation.
Jara actually emailed me a copy of it.
Okay.
So either one, we can get the original or keep the copy.
Gotcha.
Ms. Gonzalez has not yet connected to the audio.
She's getting reinforcements, it appears.
It appears.
younger aged reinforcements.
There she is.
There we go.
Okay.
Can y'all hear her?
Yes, ma'am.
Okay, there you go.
Okay.
We can hear you. I haven't heard her yet.
Yes, can you, I'm here.
All right. Ms. Gonzalez, I'm going to put you in an electronic room so that you and your lawyer can talk for a few minutes without everybody else hearing what you have to say to one another.
Okay.
Judge, is that her phone feeding back?
Yes.
Okay, I'll try to fix that when we're in the room.
Okay.
Can you hear me, Jenny? Okay.
Here we go. All right, Ms. Gonzalez, you and Mrs. Ford will be by yourselves. And,
Okay.
and when you're through, just stay online and we will come back to you.
Okay. Yes, sir.
Okay. Ms. Morris, you have a name change? Okay. It's probably gonna take a couple of minutes for me to get that file.
Can you do that while we're waiting?
If you don't mind.
You know the problem.
Kayla's got it on her desk, I know. Yes, I know she does. But it never hurts to remind me.
Judge, you may need to close that breakout room.
All right.
I asked her to leave it, but I don't see her here. So you may just need to close it.
I think she,
Oh no.
pardon?
Did she leave the whole thing?
It looks like she did.
Oh,
Let's
no.
see. No, there she is.
Okay.
All right, I closed it and we have everybody here. So let me call cause number 10,826, style the state of Texas versus Jane Gutierrez Gonzalez. This is a pretrial hearing in Ms. Gonzalez's case. This pretrial hearing is being conducted by remote video technology using the Zoom protocol and is being live streamed on the court's YouTube channel to comply with, pardon me, to comply with the Supreme Court and Office of Court Administration directives that we remain open to the public. Just for the record, we are open to the public. Courthouse is open. This courtroom is open. I have other people present in the courtroom as we are doing this, just to show that we have that the public is welcome to our proceedings. All of that said, let me also state that no one is permitted, and in fact, everyone is prohibited from recording this pretrial hearing in any fashion, except for the court's official court reporter, who is transcribing these proceedings just like he would do if we were in open session in open court, which he and I are. With all of that, for purposes of this pretrial, what says the state?
State's ready, Your Honor.
And defense?
We are ready for pretrial, Your Honor.
And we will note that Ms. Gonzalez is present in this Zoom conference as well. And in fact, Ms. Gonzalez and Mrs. Fuller have had an opportunity to consult with one another in secure breakout rooms. Now then, all of that said, Mr. Smith, on behalf of the state, does the state have any pretrial matters to take up?
No, Your Honor.
Mrs. Fuller, does the defense have any pretrial matters to take up?
We do not, Your Honor.
What do we anticipate doing in this case? That is jury trial or resolution short of a jury trial?
Your Honor, as of right now, we do not have an agreement to resolve short of a jury trial.
Okay.
I'm not saying that might not happen in the future, but as of right now, we do not have an agreement.
Yes. Okay. Because this is the month of December, and in an effort to be as totally transparent as possible, I advise that we are not going to require anybody to have a jury trial this month. It's just always been my belief that a jury would not appreciate having to report during the month of December while they otherwise would be preparing for Christmas. And they might take it out on one or both of the parties. And so that didn't seem to be fair to either party. And so we're not going to have a jury trial in December. But I do anticipate us beginning jury trials again in January. We have been approved to do so by OCA and the regional administrative presiding judge as per OCA directives. All of that said, I do not need any other pretrial matters in Ms. Gonzalez's case, but let me give the parties the opportunity to mention anything else. Is there anything else that we need to take up while all the parties are present?
I have nothing else, Judge.
Nothing from the defense, Your Honor. Thank you.
Then that will conclude our pretrial hearings in Ms. Gonzalez's case. And that will conclude our Zoom hearings this morning. We will be in recess. I will close our YouTube channel and this Zoom hearing. Thank you all.
Thank you, Judge.
We certainly hope you get to feeling better very quickly.
Thank you.
All right. We're in recess.